Hey everyone, welcome back to today's video. We've got several sovereign citizen cases to cover from a few different courtrooms. Before we dive in, I want to apologize for the recent lack of content. I took an unexpected week-long break while traveling through Europe. With that said, let's jump right into the latest sovereign citizen case in Judge Perkins' courtroom. It's a short one, but we've got 4 videos to get through today. So let's get started.
Of Detroit versus Nathan Lucas. Case number Nathan Daniel Lucas. Case numbers SP 106-84961, SP 1111617, counts 1, 2, and 3, SP 1111637, SP 1129810, counts 1 and counts 2. SP 1389565, counts 1, 2, and 3. SP 9644961, 22737166, counts 1 and counts 2, and 227371. Appearance for the record, please.
Good morning, Your Honor. Tana Jenkins on behalf of Mr. Lucas. Mr. Lucas, please place your full name on the record.
Nathan Daniel Lucas, a living man.
A living man?
Yes, sir.
I would think that would be obvious, right?
No, sir. Not in
No.
the etymology of the courts and the syntax grammar. No, sir.
You've gone above my head on that. I can't. That's above my pay grade. All right. So are you interested in a lawyer representing you, sir?
No, sir.
Okay. Are you interested in even getting a driver's license?
No, sir.
Are you interested in an offer at all?
No, sir.
Set the matter for trial.
Well, I intend to plead in the form of a demurrer, such that I do not acquiesce to quasi-jurisdiction.
Or aqua, because after you open your mouth, you'll have to explain to the rest of us that you're a living man, not just a living brain donor.
Okay.
Because that issue is to be brought up in my pleadings and filed with a court.
I didn't see any pleadings filed with the court. Do we have anything?
I said that is an issue to be brought up. My pleadings to be briefed and filed with a court.
Well, you should have done that. Today is the date and time set for arraignment on the bench warrant. Hannah here. I'll enter a not guilty plea on your behalf, sir. Give you a $0 bond, and I'll set a trial date for November the 14th, 2024. Or if you want a pre-trial date to file some pleadings, I can set that for October 21st, 2024. Which one would you like?
You could repeat that, sir?
Pre-trial date, if you want to file some motions, pre-trial date will be October the 21st, 2024. Or
that will be fine.
Just set it that you want that date?
October 24th, 2024?
October 21st.
21st.
2024 at 8:30 a.m. All right.
Yes, sir. And just for the record, I did not enter in no plea. I don't plead.
All right. Well, I'm entering in for you. All right. Have a good day, sir. I'll see you back October 21st, 2024, God willing. All right.
Likewise.
All right. That wraps up the first hearing, and it looks like we got an interesting appearance scheduled for October 21 SD. I'll be traveling again then, so you and I will be face-palming together all the way from Amsterdam. Next up, let's head over to Judge Gayer's courtroom for a returning sovereign citizen I've covered before. This time, he decided not to show up to court, which led to a bench warrant being issued. Law enforcement promptly picked him up, properly establishing the jurisdiction he keeps claiming they don't have.
Good afternoon again, Your Honor. Custody on behalf of Trevor McLeod.
All right, and all right, this is file 23-748FH. And who do we have from the people on this file?
That would be me.
Okay.
Warden Goodrich, Wayne County Prosecutor.
All right, and we're here for a docket call and also then a contempt hearing for failing to appear. But I do note that there was an absconding case filed in that matter. So Mr. Kukuski, do you know how Mr. McLeod wishes to proceed today?
Well, Your Honor, we're not resolving this matter at this time. We'd ask that the hearing be continued at this time as well, given the new charge in that matter. So
I do see that the new charge is set for an arraignment on September 10th it was at 10 a.m. You want us to continue this to the same date and time?
yeah, Your Honor, that'd be fine.
Okay, so let's continue this to a docket call to September 10th at 10 a.m. And we'll have the contempt hearing, same date and time. And that'll be the same time as the arraignment on the absconding charge as well. All right, anything further from the defense?
Briefly, Your Honor, I did want to request from the court a consideration on reinstating Mr. McLeod's bond. He is self-employed and has several jobs and opportunities lined up. This is the time of the year that he gets his work in as a contractor, kind of puts things away for the winter months. He's the sole breadwinner for his family and support for his wife and children. He's obviously no longer listening to outside forces and taking bad advice.
Bad advice? Are you serious? That's like saying eating pain for breakfast is just taking bad advice. Some things in life aren't just bad advice. They're straight-up stupid decisions you know better than to make, especially when people like me are out here on the internet fighting that nonsense with a little common sense.
He's now retained counsel. To my knowledge, he had no failures to appear. He did fail to appear one time, which led to his incarceration and his sitting and bond being revoked. To my understanding, that's not going to happen again, Your Honor. He's got significant ties to the community. He was still in the community here. And so we'd ask the court to, and even on these charges, he's not looking at any sort of lengthy sentence.
I'm not sure that's true. He's got an absconding felony charge now that's discretionary consecutive. I mean, I haven't scored it, but
Sure.
he's really made a mountain out of the proverbial molehill here.
I would agree with Your Honor. I mean, he had to lead to a disorderly person. Certainly, that's gone to the wayside at this time. But we're just asking for the court to look at all those factors and weigh that into considering a release on bond again, Your Honor, and not to, I guess, hold. He's listening to bad advice, which he's not doing anymore against him, and come down from a place of anger, but to allow him the opportunity again. Thank you.
Thank you, Ms. Gitters. People's position.
Your Honor, my concern would be the pending absconding and his demonstration on bond of failing to appear. He has had the benefit of previous counsel throughout this case. I'm glad that he has retained counsel and appears to be communicating with that attorney. However, I still have concerns with his ability to appear for future court hearings.
All right. Well, I mean, last time when I was here, I noted that we had gotten mail back from Mr. McLeod. A second one came back that I guess had been kind of lingering. And again, just for the record, when he was purporting to represent, when he was representing himself, then he refused mailing from the court. I have a second mailing back from the court. And this is not somebody else's. I mean, I don't know where he gets the advice, but this was an adult man choosing, while he's representing himself, to write on it in red ink, return to sender, 18 U.S. Code 241-242, your offer to contract is not accepted, as if a defendant facing a pending felony charge has some ability to reject a contract and ignore the case.
Wait, are you seriously saying I can just go out and rob people, then tell the courts I don't consent to the laws and won't be held accountable? Just think about all those people wasting their lives in prison, not because they broke the law, but because they forgot to write it down in red edible highlighter that they don't contract with the government.
So this was really quite a willful refusal to acknowledge even the authority of the court, and an outright refusal to appear, resulting in a forfeiture of the bond. And I mean, when people are facing a felony case, even though this wasn't the most serious felony case that we see, it is nonetheless serious. It's in the circuit court, court of general jurisdiction. People don't just get to opt out of that and say, I don't think the courts have any authority over me. Well, guess what? They do. And so I just have no confidence that Mr. McLeod respects the authority of any governing authority and that he would appear. He's refused to appear and now has an absconding charge. So his bond will continue to be revoked until the conclusion of these cases.
As it should be. Let this serve as a lesson, or some good advice, to anyone whose family depends on them for food and shelter. Choosing not to contract with the government while actively breaking the laws of this country can lead to serious consequences. Now, let's head to Georgia, where we've got two sovereign citizens, both in wheelchairs and each uniquely clueless in their own way.
What is your name, sir?
Whitlock.
Whitlock? All right. Mr. Whitlock, you have appears to be duplicate charges, so some of these charges are going to be dismissed, and you have two separate incidents. Because you're on active probation for the felony charges, I cannot provide you bond. So for the aggravated assault on police officer, fleeing a police officer, and for the obstruction felony charge, there will be no bond. For the theft by taking, that'll be a $1,000 charge as a misdemeanor. For the second incident, there is a no license charge just being dismissed because there is no facts to support it within the warrant. The tinted window will be $500. Use or possession of drug-related objects, $1,500. Identity fraud, no bond. Crossing guard lines, 2 counts, no bond. The wanted person charge is going to be dismissed because that's something separate totally from this incident. And giving false name or address or date of birth will be dismissed because there are no facts to support it in the warrant. So again, you have 2 counts of aggravated assault. One of those is going to be dismissed because there appear to be duplicate incidents. 2 counts of fleeing an officer. One of those is going to be dismissed. But at this time, there's no bond, which I can confirm which one's going to be dismissed. You'll have a minute to ask your question, Mr. Whitlock. I'm not done. The theft by taking misdemeanor, 2 counts, $1,000, and the obstruction of an officer is no bond. Your preliminary hearing is currently set for September the 9th at 8:30 a.m. In regards to court-appointed counsel, Mr. Whitlock, are you working? Did you want to be considered for a court-appointed counsel?
Oh, no, I don't want court-appointed counsel, but I do not proceed to I do not.
Hold on. So you're going to hire your own attorney?
Yes, ma'am. I don't consult to the proceedings, and I would like to say things like I already know how it goes.
I don't think you really get it, because you just said you don't consult or concede to these proceedings, when the sovereign citizen script is all about not consenting to them. Am I the only one who finds it highly ironic that is in a wheelchair right now and charged with fleeing and eluding? Either way, is about to say and do something even more ridiculous.
With the things about crossing guard lines, I'm in a boot, and I was with the officer the whole time. I told them they need to use their cameras here because they found a bud of weed in my boots.
Wait, your dad's a detective, and you still think you can just refuse to consent to the law is sworn to uphold? I'd ask you to explain that, but there's not enough thermometer juice in the world to make sense of it.
Mr. Whitlock, you say you know what's going on, so you know this is being streamed live.
Yeah, I know, but that don't say I'd rather be charged for that than when they're putting on me. They found that on a water fountain. I don't even know what a water fountain is. I was with the officer the whole time. Even the officers in there said, man, this is going to get thrown out because the officer was just being an a-hole and putting everything on me. I had none of that. I was with the officer the whole time. You could tell them.
Mr. Whitlock, this is not a hearing. I don't have the officer here. So when we have the hearing, all this can be brought forward for your preliminary hearing or for, your attorney who you hire who can help you negotiate this. Again, I'm advised this is not a hearing. This is just to tell you what you're charged with. So any other questions?
If I say I do not consent with these proceedings though, and I do not accept the terms, like.
Okay.
Yeah.
Well, you can discuss that with your attorney. If you have no other questions or comments, you're free to go.
Now, this one more question, man.
Okay.
That with what you was just charging me with, that had been in College Park. So is that a part of y'all?
College Park is in Clayton and in Fulton, sir.
Yes, ma'am. So I'm wondering, I thought I had to deal with Fulton County on that instead of Clay.
looks like you have some Fulton charges as well, so.
Yeah, but the Fulton County charges is someone else. That's the way they actually locked me up and then let me out the hospital once he found out it wasn't me. So why they're still on me? Like
This charge, let me just tell you, the charge that you're for the aggravated assault that was in College Park, it is on or around July 28th. It happened. So that is not the Fulton County one that appears to have happened around July 17th. So there's
Clayton County.
Yeah, if the warrant was sworn out for Clayton County. Yeah.
Okay, ma'am. That's all I was asking. Because I know that's going to get handled. That's some BS. But because I ain't did that. My father is a police officer, a detective, so I'm not worried about it. I know there's BS.
You can demand a bond all you want. But since you're on probation and charged with new felony offenses, Georgia Code 17-10-1D states that anyone on probation facing new felony charges must be held without bond until a revocation hearing or bond redetermination hearing by Superior Court Judge.so. You're not getting out of jail today. Now, let's stay in Georgia for our final hearing. It's a short one, but
it's one thing. Those charges that I have in Fulton County, those warrants, I had got locked up in front of the ledges on Old National. I know this not, I just want you to understand. I got locked up in front of the ledges on Old National. I have 2% in the ledges. The man even told him, hey, yes, he owner, he's an owner. And they still, hey, let me search you and all that. Now, once they searched and seen I was clear up good, I know the officer, I buy them food. And the dude that was in, I also rent cars out. I have a Maserati truck. I was renting out at the time.
Mr. Whitlock, I'm going to stop you there. Because you're doing too much. You're talking about Fulton County. I was trying to let you go for it and explain.
I need some professional help.
Okay, well, you said you're hiring your own attorney, so they'll be able to help you with those charges, sir. Good luck.
I'm gonna have an attorney for the charge, but since you're a judge, you could tell me why did they let me go? They let me go.
I can't tell you what happened in that case. I don't have those facts before me. I only have the ones I'm dealing with right now. So you're free to go. Thank you.
So what's my bond?
You have no bond because you're on probation.
I heard you give me a couple of numbers also.
There was for the misdemeanors, there's like $1,000 and $1,500 for the remaining felony charges. Those statutes don't allow a judge to give you bond if you're on active probation for felony charges.
Yes, ma'am. But even in Fulton County, they don't allow.
It's the laws of Georgia, yes, sir.
Okay. I thank you, ma'am.
You're welcome. Have a good day, sir.
Mr. Williams, you are.
You say, talk to my lawyer, right?
Yep.
And even if I say I demand a bond immediately.
More short on sense than the rest of us. Dumber than the rest of us.
What's your name, sir?
I am Moore.
Moore?
Nailed it. At this point, if you choose to follow the Moorish Science Temple of America or any other pseudo-legal group, you're clearly mentally and socially challenged and should be locked up for your own safety and the safety of those around you.
Special representation. I'm asking you.
Your Honor, his name is Tyrese Breland.
Breland?
That's not my name.
Oh, Breland.
That's not my name. I am Moore. I'm here on special representation.
Same as last defendant, Your Honor.
My honor, I'm asking.
Okay.
What is your status and what is your name? I'd like to know your name. I'd like to know your status. Of everyone in the courtroom, I would like to know what is your nationality and what is your
deputy.
Yes, ma'am.
I would like to know your nationality.
He has charges in jots and he has a paper charge. Let me see if they're the same warrant. And they're different warrant numbers. Okay. So I guess I do both sets. Let me see when these are.
Know your nationality. I would like to know if you're a U.S. citizen of the United States. And so what is your status? You're a U.S. citizen of the United States?
All right, hold on one moment, sir. Let me review the warrant.
I'm asking you for your status and the status of everyone in the courtroom. I would like to know your name. I would like to know the nationality. I would like to know, are you a U.S. citizen? once again, my
Is he injured, deputy?
status
Say it
of
again, Your
everyone
Honor.
in the
Is
court.
he injured? Is that why why is he in a wheelchair?
Yes, ma'am.
I would
Okay.
like to know the status of everybody in the courtroom. I would like to know your name. I would like to know your nationality. I would like to know are you a U.S. citizen?
Deputy, do you believe that this gentleman is mental health, or do you think it's just a sovereign citizen
Can you
thing?
provide me with the information?
Both.
All right, guys, that's it for today's video. I've got one more wild courtroom moment with a crazy Karen before I head back to America. If you enjoyed this video, be sure to hit the like button. If not, feel free to hit dislike, but don't forget to leave a comment below and subscribe with notifications turned on so you never miss any of my content.